Hello, welcome to the Grow Your Wealthy Mindset podcast, where it is all about helping amazing physicians just like you create a wealthy life free from burnout and with the financial security to practice medicine on your own terms. I'm your host, Dr. Elisa Chiang. Hello, and welcome back to the Grow Your Wealthy Mindset podcast. Today's episode is on estate planning, and I can't believe I actually haven't had an episode on estate planning yet. Part of financial planning is estate planning. As your portfolio grows, and especially if you have children, you'll want to plan for your assets for when your time on earth is over. Now, bear in mind, I am not an estate attorney, so nothing I say here is legal advice. When it comes to implementing your estate planning, I would recommend working with an estate attorney. What is involved in estate planning? In my opinion, everyone, regardless of their assets and net worth, should have a healthcare proxy and a durable power of attorney. In the healthcare field, we know that something can happen to anyone at any time, which can make them incapacitated and unable to state their own wishes. You want to decide before that time comes who would make healthcare decisions on your behalf, with your wishes and beliefs in mind. It's also beneficial to have a living will, which contains instructions about your preferred medical treatment in situations where you aren't able to make those decisions for yourself. We in healthcare understand a lot more about treatments and what we may or may not want than our family members probably do. While it's great to have conversations with your family about your wishes, having it in writing is even better. In your living will, you can specify certain actions you want taken, as well as medical treatments you would refuse. You could also specify how long you want to prolong your life. So that addresses your healthcare proxy and your living will. You also want to designate someone who would make legal decisions on your behalf should you become incapacitated. This is done through the durable power of attorney. Your durable power of attorney can make both legal and financial decisions on your behalf when you're incapacitated, differing from an ordinary power of attorney, which expires if you become mentally incompetent, or on the date or event stated in the power of attorney document. Your durable power of attorney can do things like buy and sell property and other assets, manage bills, bank accounts, and investments, file tax returns, and apply for government benefits. If you don't have a durable power of attorney, your family may have to go to court and have you declared incompetent before they can actually take care of your finances for you. You can have the same person be your healthcare proxy as well as your legal proxy, or they can be two different people. If you have assets or you have children, it is beneficial to have a will. Your will represents your final wishes for your estate to be carried out on the event of your death. If you die without a will, then your assets will go through a process called instate. In this process, all your assets are frozen until the court system goes through the details of the estate, which can be a long process. Every state has their own established instate process that determines how a person's assets will be distributed, generally among their spouse, children, parents, or siblings. This can all be avoided by having a will in place. Your will gives instructions on how your estate or assets will be distributed, and you can designate who receives how much. You can state how much money someone gets, or who gets the house, or who receives any items of sentimental value. In your will, you can designate who cares for your underage children. There are some limitations with the will. There are assets, like life insurance payouts, that will be distributed to the beneficiary on file and not who's listed in the will. Most states have an elective share or community property laws to prevent people from disinheriting their spouses. Any court can override a will if the will assigns a smaller portion of such assets to the surviving spouse than the state law specifies, which is typically somewhere between 30 and 50%. For a basic will, you don't necessarily need an estate lawyer. Using an online service like LegalZoom.com can't suffice if you don't have a lot of assets. Again, that's not legal advice. After death, one's estate generally goes through a process called probate. Probate is the analysis and transfer administration of estate assets. Probate court will determine if the will is authentic and valid and will appoint the executor, generally the one named in the will, or an administrator if there is not a will, to pay off any outstanding liabilities and then distribute the assets of the estate. The executor is also responsible for filing the final personal income taxes on the behalf of the deceased. Any estate taxes that are pending can also come due within 1 year from the date of death. After the inventory of the estate has been taken, the value of the assets calculated, the debts paid off, the executor will then seek authorization from the court to distribute whatever is left of the estate to the beneficiaries. The probate process can be long and expensive. What's more is that probate is a public process. This means that all the assets of the estate will be open for public knowledge and scrutiny. Trust can be set up to avoid probate, but before I talk about trust, I think this is a good time to go into estate taxes. Depending on the size of your estate, there may be estate taxes. In 2023, the federal limit is $12.92 million per person, and this is indexed for inflation. This means that if your estate is less than $12.92 million, there are no federal taxes due on the estate. Federal estate tax is only paid on amounts greater than the $12.92 million, for which there's a base tax as well as a marginal rate. Current federal estate taxes max out at 40% for taxable amounts greater than $1 million. Of course, estate laws change over time. The current federal estate exemption is portable, meaning that if one spouse dies and doesn't make full use of the exemption, then whatever is unused can then be added on to the surviving spouse's own exemption. But this does require that the executor of the first deceased spouse to file an estate tax return to elect for portability, which is not automatic. Tax Form 706 must be filed within 9 months of the spouse's death in order to elect portability. If the survivor remarries, the ported amount is lost. States may also have their own estate taxes, which is levied if the deceased is a resident of the state that has an estate tax. As of 2023, Washington, Oregon, Minnesota, Illinois, Maryland, Vermont, Connecticut, New York, Rhode Island, Massachusetts, Maine, Hawaii, and the District of Columbia all levy estate taxes. Most estate taxes by the state are not portable. Some states also have an inheritance tax. Estate taxes and inheritance taxes are not the same thing. Estate taxes is a tax on the privilege of the estate to transfer property to the heirs of the deceased person. It's the estate of the deceased that's liable for the tax. In contrast, inheritance tax is a tax on the privilege of receiving property from a deceased benefactor. The living heir pays an inheritance tax, not the estate of the deceased. There is a federal estate tax, and in some states, a state estate tax. The federal government does not levy any kind of inheritance tax, but there are 6 states who currently have inheritance taxes. As of 2023, the states that have inheritance taxes are Nebraska, Iowa, Kentucky, Pennsylvania, Maryland, and New Jersey. Maryland is the only state in the country that currently levies both an estate tax and an inheritance tax. Inheritance tax is due if the person who inherits money is a resident in a state with inheritance tax. Spouses are exempt from paying an inheritance tax in all 6 of those states, and some states extend that exemption, at least partially, to all immediate relatives. So now this is a good time to transition to talking about trust. Trust can help wealthy couples with assets close the double estate tax maximum of about $25 million, maximize estate tax limits, though for most of us, we don't really have to worry about estate taxes. As much money as we make as physicians, as much as I want you to build your wealth, most physicians do not get to the point where they have a net worth of over $25 million for a couple. However, there are other reasons to set up a trust, and the biggest one is privacy. As I stated before, the probate process is a public process. A revocable or living trust is a trust that can be changed or canceled by the grantor. With a revocable trust, your estate avoids probate. This allows your estate to be distributed privately, protecting your heirs and yourself from a public hearing about the contents of your estate. It also allows for a faster distribution of your estate to your heirs and can save money in court fees that would get deducted from your estate otherwise. Not everyone needs a revocable or living trust. If you don't plan to leave much behind to your heirs and don't mind this being public, or you plan on leaving everything to charity, you probably don't actually need a revocable trust. Revocable trusts are different from irrevocable trusts. An irrevocable trust is one that cannot be revoked or changed. The grantor of an irrevocable trust loses control of any asset placed in that irrevocable trust. When you create an irrevocable trust, you as the grantor dictate the rules of the irrevocable trust, the assets of which can be used by the beneficiary or beneficiaries. A designated trustee oversees an irrevocable trust. The advantage of an irrevocable trust is that it can decrease the size of your estate once you grant the asset into the irrevocable trust because it's no longer yours. It really belongs to the irrevocable trust. You can put an immature investment in an irrevocable trust and allow it to grow outside of your estate. The assets become accessible to your beneficiaries in the future if granted approval by your named trustee. When creating the irrevocable trust, you can specify certain stipulations before beneficiaries can access the assets within the trust. Another advantage of the irrevocable trust is that assets in the trust are shielded from creditors of the grantor, since the assets are no longer owned by the grantor. The assets of the irrevocable trust are not subject to estate taxes, though gifts of assets into an irrevocable trust that exceed the annual gift tax exclusion limits will count against lifetime estate and gift tax exclusion and require you to file a tax return. Generally, an irrevocable trust is something you may want to consider later on in your life, after you've built a significant amount of wealth, and not generally during the time that you're actually working on building your wealth. This may be somewhere in your 60s or 70s or 80s when you're really thinking about how you want to distribute your wealth to your beneficiaries and heirs. That's the time to start thinking about an irrevocable trust. An irrevocable trust can be made anytime you start to actually develop some sizable assets that you want to leave your heirs. Creating a revocable trust is best done through an estate lawyer and generally doesn't have to cost a lot of money. Because there are differences between different states regarding estate and inheritance taxes, you do want to get an estate attorney that is familiar with the rules of the state that you are resident in and possibly the state that your heirs are resident in if they're unlikely to move before the time of your death. Referrals are generally a great way to find any kind of professional. I know estate planning is a rather dry topic, but it is still good to have knowledge about estate planning. I hope the information presented today was clear, but if you have any questions, feel free to reach out to me at growyourwealthymindset@gmail.com. Thanks so much for listening to the Grow Your Wealthy Mindset podcast. I really would appreciate that if you're enjoying this podcast, that you would leave a 5-star review at whatever podcast app you are listening to this podcast on. Thanks so much. If you enjoyed this episode, I would love it if you could share it with your friends and colleagues. And now for the disclaimer. I am not a certified financial planner, accountant, or attorney, and nothing I say should be construed as professional investment, tax, or legal advice. This show is primarily for your education and entertainment. I am a physician, but I'm probably not your physician. So if you need any medical advice, please contact your own physician. Thank you.